Today, we're talking about a crime in Arizona called misconduct involving weapons, and specifically the best offenses that we often see in these types of cases. So in other videos, we've explained what misconduct involving weapons is. Today, we're going to talk about how to attack some of the elements of the law and what some defenses are that may or may not be applicable in your particular case, or if you're watching this for somebody you love, their case. So let's jump into it. So the first thing that we see in most cases is there's a question about knowledge. So did the person who have the weapon that is alleged to have been in their possession, did they know about it? Did they know that the weapon even existed? We see this in most commonly in situations where somebody is stopped in a car. It's a prohibited possessor, somebody had a conviction for a felony, and there's a weapon, there's a firearm in the vehicle. And so it's very common with what's called a prohibited possessor. Was that person even aware of the weapon? Was the weapon in the glove box? Was it in the trunk? Was it under their seat? A lot of the times the police will try to say that they knew about it or they should have known about it, and that therefore that is within their possession. They had full knowledge of it. If you can show that there was no actual knowledge, if there's no indication that the person knew that there was even a weapon there, how could they possibly be in possession of something they did not know existed? And so what we want to look for in these types of cases is the question as to whether or not the person who's being charged with the crime, did they make any admissions? Did they make any confessions? Did they acknowledge the existence of the weapon? If the person said, yes, I knew the weapon was there, or yes, I knew that was in my possession, but when I got pulled over, I put it under the seat, well, that's going to make that element pretty difficult to overcome. But a lot of the times what the police will do is they will twist somebody's words around. So the person will acknowledge certain things and the police will connect the dots. They'll take a lot of their statements and then suddenly imply that they meet the element of knowledge. And so not having knowledge about the existence of something is very important. If you can show that there was in fact no knowledge and that none of these admissions or confessions or acknowledgement or any awareness of it existed, you might be able to beat that element of the underlying charge. Closely related is the next defense. It's called possession. So is there what's called a sufficient nexus between the person and the weapon? So is this something that the person, they may have known that the weapon existed, but were they actually in possession of it? If you look up the statute, the definition of possession under the Arizona Revised Statutes, you're going to see language that says dominion and control. So did the person have actual possession of the weapon? The example that we use is, say there's a situation where there's 2 roommates or 3 or 4 roommates and they all live in a house, and so the person who's being charged with misconduct involving weapons, he may have known that other roommates had weapons, but was he actually in possession of those? So it's called prohibited possessor. Did that person actually possess the weapons? If they were in close proximity to that, but they didn't exercise any dominion or control over the weapon itself, it wasn't theirs, it was in their roommate's room, it was in a common area, something along those lines, you can show that that person who's being alleged to have been in possession was in fact not in possession, and that's a key element. They have got to prove actual possession or constructive possession. There's a lot of legal jargon that we can get into on that, but that's the element. That's what you're looking for. Who was actually in possession? Who had dominion? Who had control over the weapon in question? The other thing we wanted, of course, determine, was it actually a weapon? This is more in common for offenses that don't involve firearms, so things like explosives or dry ice bombs or explosive things where you have a series of chemicals that could be mixed for legitimate purposes. They could also be mixed for weapon purposes. So you want to make the argument that it in fact wasn't a weapon. It was used for other things. We're using it for demolition. We're using it for construction. We use it for a science experiment. We use nunchucks for martial arts training. It's not actually being used as a weapon, and so you make the argument, make the case that it's not actually a weapon. So you may be a prohibited possessor, you're somebody who was convicted of a felony, but that doesn't mean that you were actually in possession of a weapon, and it shouldn't be governed by the misconduct involving weapons statutes. So if you can show that it wasn't in fact a weapon, you want to do that because that's going to defeat the charge. Another big part of misconduct involving weapons, if you look at the statute, it's very, very big. There's a lot of definitions. There's a lot of exceptions and exclusions where the actual language doesn't apply. There's certain areas where there are exceptions that are carved out of the statute. So, for example, if you are using a weapon for mixed martial arts, if you're using it in a lawful demonstration, it's going to take it outside of the misconduct involving weapons statutes. Sometimes prosecutors, police officers, they overlook these exceptions. So you want to make sure that you're running through that statute with a fine-tooth comb, see if any of the facts in your case would be applicable to one of the exceptions. And that way, some conduct that would have been ordinarily covered by the statute, we now pull it out. So statutory exclusions is a big part of it. And then, of course, we look at the common evidentiary problems. So if the police are saying that they found a weapon and they believe that it was a prohibited possessor's or was in somebody's possession who was a convicted felon, and so therefore they are not allowed to have that, how can they make that connection? What type of evidence can they bring into court and introduce to show that that person did have possession? So when we're looking at those things, we're looking at these types of components. First of all, was there any chemical testing that was completed on explosives, on firearm residue? So when you shoot a firearm, it emits a big plume of smoke, and there's residue, gunpowder, that will actually go on your hands, on your clothing, and those types of things. So are they able to actually make that connection? Are they able to show that there was gunshot residue that connects the person to the firearm? Similarly, fingerprint connection. So is there any actual fingerprint residue? Are they able to do some forensic testing on that and see if they can pull those fingerprints off the firearm, off the explosives, off whatever the prohibited weapon is? Are they able to do that sufficiently? Is there any way that we can undermine their credibility? Did they do it properly? Can we have an expert witness come in and say they did not do it properly? That's another component. Same thing with DNA testing. We'll do this where there's skin or other DNA material that would be connected to certain devices, certain weapons, certain firearms. You want to make sure that those are being tested appropriately, identify potentials for false positive and those types of things. You're also looking for photo lineups. So if there's other witnesses who were involved, people who are going to be identifying a person as being the person who fired the firearm or who was in possession of the firearm or who was manufacturing X, Y, and Z, are they able to properly identify that? Was there any undue influence during the photo lineup process? Were the police doing anything to bias that individual, picking out the person who they're claiming was at fault for this thing? So there's a lot that goes into that. There's a lot of psychology. There's a lot of review of the evidence, of the video footage, of the recordings, of the other people who are in the lineup. What kind of influence did the police have over that process? That may be a big problem. And of course, you're looking at Miranda violations. So this is pretty common amongst a lot of criminal cases. But did the police do their interrogation properly? Did they Mirandize an individual properly? Were any of these statements, admissions, confessions, were those taken in violation of Miranda? Miranda was a case that was decided in Arizona a couple decades ago. And so it is a very important thing that sometimes the police get a little bit sloppy with. So they'll start asking questions in violation of Miranda. And so if you can show that there was a violation there, any of those statements that you made may not actually come into court. We want to look into those things as well. So if you've been charged with misconduct involving weapons, there's a number of different ways that you can be cited and charged with this. Give our office a call. These are just the very topical defenses that we see sort of out of the gate on a lot of these things. You want to make sure that you're covering these bases. But there are many other defenses that are applicable in misconduct cases and criminal cases across the board. So give our office a call. We offer free case evaluations. We're happy to sit down with you, put together a plan to make sure you have a good understanding of how we can get you through this with the least amount of damage possible. We look forward to speaking with you. Thanks for watching.